There's a lot of discourse in the legal community about the culpability of those whose brains have not fully developed. Although people in their early 20s are allowed to drive, to vote, to sign up for the armed forces, to purchase guns and ammunition, and to consume intoxicating substances, their brains aren't fully wired and they're still learning how to interact with the world around them. That's why college has such a reputation for being so formative. Your brain is still developing, and you're meeting all kinds of new people with experiences and life stories that are different than your own. And your brain is processing all of that information and all of those relationships and shaping your worldview. Those formative years give you the opportunity to outgrow your high school hometown self. The military offers many of America's young women and men that same opportunity. Senior Airman Greene-Watson didn't make enough of that opportunity and jumped into a hasty marriage and fatherhood without dealing with his own issues around abusive power and control. This is Conduct Unbecoming. I'm Erin, and I'm your host. I'm dropping a quick listener's note here to remind everyone that this episode discusses domestic violence, as well as a coercive power dynamic. It will include discussion of violence against a 3-month-old, which might mean this isn't the case for you. Jaquan Greene-Watson joined the Air Force, as best I can tell, sometime in 2016. I have no problem admitting that my estimate is based off assumptions from his online presence because he doesn't actually list his time in the Air Force. I believe Kirtland Air Force Base in Albuquerque, New Mexico was his first duty station. Although I can't be terribly precise with his origin story, I do know that by the end of 2018, Greene-Watson was stationed at Kirtland and met a woman we'll call Madison. When they met, Greene-Watson was approximately 20 years old, and Madison was, by my best estimate, 17. Nevertheless, the two hit it off and were married by March 2019. I don't have to tell you that's quick. You're all able to do the finger math and conclude yourselves that that's quick. About 6 months after their wedding, they had a little bundle of joy on the way. Their son, who we'll call James, was born in June 2020. Yes, that 2020. You and I have talked before about the increased likelihood of domestic violence for pregnant and perinatal women, and we've discussed that experts warned in the early days of COVID of what was sure to be a shadow pandemic, an increase in violence for victims under stay-at-home orders with their abusers. By September 2020, things began to get rocky for the 22 and 19-year-old. On September 19, 2020, Greene-Watson and Madison slipped into an intense verbal argument at their home. It wasn't a squabble over whether they could afford an overly large set of furniture from Ashley or whose family they'd visit for the holiday. The argument started when Madison confronted Greene-Watson, accusing him of trying to suffocate James, just 3 months old, in his crib in their nursery. Madison said she'd heard crying when she hung up on a Zoom call, and that when she followed the sound to James's room, she opened the door and found Greene-Watson holding a washcloth over James's face. The argument escalated when Greene-Watson started snatching at James. I think the Air Force Court of Criminal Appeals could have used one more edit because somehow the following sentence made it through to filing. Appellant attempted to wrest hold of James away from appellant, but appellant refused to release him. There were only 2 adults in the room, and I don't think Greene-Watson was struggling with himself over James, but I've read that sentence at least 11 times, and the best guess I have is that Madison was trying to prevent Greene-Watson from reaching James in his crib. Whatever that initial struggle, Madison grabbed Greene-Watson's arm, but was unable to prevent him from reaching James. He lifted James by his armpits and, if Madison's memory is accurate, began shaking him. Greene-Watson pulled away from Madison, entered the primary bedroom with James, and locked the door behind him. Madison reported hearing Greene-Watson screaming at James and James crying. When he finally unlocked the door, Madison scrambled forward to retrieve her son, but Greene-Watson told her that if she came near him, he was going to throw the baby. She froze and watched her husband walk over to a nearby desk. After he sat and put James in his lap, Madison saw her opportunity and picked him up. This caused Greene-Watson to stand, ball his hands, and put his fists up. He feigned a swing, making Madison flinch. He told her that's why she was scared. Then he took an actual swing, missing Madison and grazing the top of James's head. Madison worried that James would be in more danger in her arms if Greene-Watson was going to continue to take swings at her, so she laid him down on their couch. After she set him down, her husband shoved her to the ground. When she regained her footing, she picked up James, retreated downstairs, and began recording audio on her phone. She originally had her phone upstairs, but believed at some point during their altercation, Greene-Watson had thrown it down the stairs. When he followed her, Madison again confronted him. She told him James could have died from his actions. In response, he said he didn't give a fuck and that if James died, he'd be happy. He warned Madison that if she kept trying him, she better not come back to the house. He told her that if she walked out that door, she better not try to come back if she wished to continue breathing and trying to live a life. He told her the only way she should return is if she had police with her, presumably to stop him from doing something. Madison took heed of that warning. She gathered James and left, bundled him into his car seat and drove away, traveling to a gas station down the street. First, she called her mother, then 911. Emergency dispatchers directed her to return home, but to wait outside for police. While Madison spoke with one dispatcher, Greene-Watson spoke with another. In his version of events, his wife was overreacting because he had just been playing with James's jaw, bobbing it up and down, trying to get him to be quiet when Madison began inexplicably screaming at him. Police interviewed both parents separately and allowed Madison to take James to a hospital to get him checked out. He spent 3 days there. Albuquerque police took Greene-Watson into custody. From my understanding, typically separating someone from their abusive partner following claims of abuse goes one of two ways. Sometimes the separation and safety fortifies a victim of abuse, and they begin to share more details of their story. And other times, separation reveals inequity in finances or earning potential, and victims of abuse begin to walk back their claims or downplay the severity. Following Greene-Watson's confinement, Madison began to minimize the severity of the incident with James. She began to toe the party line. At his bail hearing, she swore Greene-Watson was trying to calm James down, not to harm him. With this change, civilians released him from custody and he returned to their shared residence. She made similar recantation-flavored statements to the Air Force Office of Special Investigations. Civilian prosecutors dismissed the action on October 24, 2022. It's interesting to me, so I'll assume that it's interesting to you. The charge Albuquerque prosecutors dropped was a charge for violating a restraining order prohibiting domestic violence. I find that interesting because in order to violate a domestic violence restraining order, there has to be a domestic violence restraining order in the first place. Which would seem to suggest this was not the first incident. The Air Force set the court-martial for March 2022, and Greene-Watson and Madison continued to live together with their son. But about a month before the court-martial, that changed. And by the time Madison was called to testify, she'd retracted her recantations and affirmed her allegations that Greene-Watson threatened her and was violent towards their son. And all that happened because on February 6, 2022, Greene-Watson picked a fight, sending Madison text messages criticizing her for going shopping with her mother. As he described it, Madison was making excuses to not watch her son. This is a great time to reiterate that fathers watching children are parenting, not babysitting. It was just as much his responsibility to raise James as it was Madison's. When Madison returned home, their argument escalated. Greene-Watson again threw Madison's phone, this time specifically to prevent her from recording their interactions. He then physically restrained her and tried to prevent her from leaving the home. Madison was able to escape and checked into a hotel to create some distance. But Greene-Watson failed to cool down. He harassed her with persistent phone calls on the 6th and 7th of February, demanding she return with their car. When that didn't suffice to reassert control over Madison, he drained their checking account, shut off shared credit cards, and shut off the utilities to the house before she returned on the 7th. Madison described Greene-Watson pinning her down and twisting her side with his hands, balling up his fists and acting like he was going to hit her, threatening to put a bullet in her back, and that he placed himself behind the vehicle when she tried to flee. Madison said this was his modus operandi, and that he turned off the credit cards and took the car keys when they'd had arguments in the past. It seems clear that he could control her financially and could limit her movements by restricting access to the car. And that September 2020 incident taught Greene-Watson the power of a preventative story. He'd called 911 on February 6th to report that Madison was trying to steal his car, the car that the two shared legally. Evidence related to the February 6th, 2022 incident came in at Greene-Watson's court-martial under Military Rule of Evidence 404B. Greene-Watson faced charges for suffocating James and for communicating a threat, specifically what Madison captured in her audio recording. Madison had to answer the kinds of questions that victims of domestic violence dread. Why did you stay? Why didn't you leave? Why didn't you do something to protect yourself? She told the court that she continued to live with Greene-Watson following his release from jail because she was financially and emotionally dependent on him, and explained changing her testimony because she was trying to protect him. She was just trying to get him out of jail. I think it bears repeating that Madison was just 17 years old when she met Greene-Watson, and just 19 years old during that September 2020 incident. Greene-Watson elected to be tried by a military judge sitting alone at general court-martial. He'd pled not guilty and was adjudged guilty only of the charge and specification of communicating a threat. He was acquitted on the charge for suffocating James, likely because of the many changes in stories. On May 17, 2022, the military judge sentenced Greene-Watson to confinement for 3 months, reduction from E4 to E1, a reprimand, and a bad conduct discharge. From the Albuquerque Register of Actions, it's clear Greene-Watson stayed in the area after being discharged from the Air Force. He received a ticket in February of this year for going 46 in a 25, and I think failing to produce his registration when he was ticketed. I didn't see any dissolution or child custody action in the New Mexico court system, But that's not to say that Madison and Greene-Watson remained together. Each state has different approaches to case file access and just how private to keep family law matters. On appeal to the Air Force Court of Criminal Appeals, Greene-Watson raised 5 separate assignments of error. He, of course, challenged the factual and legal sufficiency of his conviction, alleged an evidentiary error in admitting evidence of the February 2022 incident, raised 2 purported issues with Madison's unsworn statement, and questioned whether his sentence was inappropriately severe. The AFCCA elected to discuss 3 of the issues and deemed 2 of them completely meritless. When Greene-Watson challenged the factual and legal sufficiency of his conviction, he wasn't arguing that he didn't say what was captured on the audio recording from September 19, 2020. Rather, he argued that what he said wasn't of a threatening nature because Madison wasn't scared of his threat, and that what he said wasn't wrongful because he didn't intend for Madison to perceive "don't come back if you want to keep breathing" as a death threat. It wasn't a direct challenge to each of the elements of the offense, but it was pretty close. The AFCCA was in their feelings about the paucity of case law about the offense of communicating a threat, but cited the Court of Appeals for the Armed Forces Harrington opinion as the most recent. For more information on that case, give episode 19 a listen. Harrington incorporates the reasonable person standard into evaluating whether something is a threat, and evaluating the subjective intent of the speaker. This particular area of jurisprudence may be significant as America continues to walk this particular path. I guess, more specifically, what this administration construes as a threat is pertinent. Where the Federal Department of Justice describes language about Teslas to be domestic terrorism, it will naturally have a chilling effect on the exercise of the First Amendment right to free speech. Greene-Watson asserted that the language he used was not a threat and was therefore protected speech he shouldn't be criminally prosecuted for. He necessarily argued that a reasonable person would not experience his language as a threat, and that Madison clearly didn't consider it a threat. Of course, the law isn't about whether Madison was scared, it's about whether the reasonable person would be. But frankly, I think it's dishonest to argue that Madison wasn't scared by his language. She immediately left the house with her son, called her mother and the police, and when he told her that if she wanted to continue breathing, she shouldn't return to the house without police, she waited outside the house until police arrived. Then, at the court-martial, she testified that she had been scared, sad, horrified, and shocked. And that testimony was consistent with her 911 phone call. If you wish to continue breathing, don't come back is, on its face, a death threat. A reasonable person would take those words at their value, and the reasonable person wouldn't even have to infer tone, because the court had an audio recording of the threat. Greene-Watson urged the AFCCA to consider the surrounding circumstances in order to properly contextualize the statements he made, but that argument seems self-defeating. The words were yelled during an impassioned fight that started when Madison accused Greene-Watson of trying to kill their baby, during which he retreated to a locked room with the baby and screamed at him, hit the baby when trying to punch Madison, threw Madison's phone downstairs, threatened to throw the baby, and in the context of shoving Madison to the ground. The only circumstances I can envision in which contextualizing his threat made his threat so obviously less threatening is if they'd routinely found themselves in similar circumstances, that he'd routinely made death threats that he didn't act upon. He contended that he made the statements while in a highly emotional state, in an unplanned reaction to Madison's claim. But aren't those the exact sort of circumstances, the exact context that you'd anticipate someone making a death threat? The arguments around communicating a threat are necessarily interwoven, so we'll come back to this context piece in just a moment. Greene-Watson also argued that his supposed threat was conditional. It was only a threat if Madison returned to their shared home, which, he claimed, negated the immediacy of his implicit death threat. The court found that argument wholly unavailing. The AFCCA then turned to whether Greene-Watson's argument on the wrongfulness of his statement had any merit. He argued that he didn't have the intent to actually kill Madison, so his statement wasn't wrongful. His argument failed because wrongfulness in communicating a threat doesn't come from intending to kill Madison. It's in intending Madison understand his communication as a sincere threat. Looking back to the context that Greene-Watson tried to couch this all in, he made this statement about the conditions under which Madison could expect to continue breathing in an unplanned reaction to the accusation Madison made, but also in the midst of the fight that ensued. And he told Madison that she could expect to, stop breathing if she returned to her legal residence. Even if he would have leveled out and cooled off before actually committing murder, it's pretty evident that he was sincerely threatening Madison. And he wanted Madison to believe what he was saying. He wanted Madison to stay away. When you look at this incident, the death threat wasn't the first threat that Greene-Watson made during their altercation. He threatened to throw the baby if Madison came closer. So Madison didn't come closer. After that threat, which Madison clearly, sincerely believed, Greene-Watson shadowboxed at her and seemed to be pleased when she flinched. And he continued swinging at her, eventually grazing the top of their baby's head. When Madison was able to put the baby on the couch, Greene-Watson shoved her to the ground. I think it's pretty clear that Greene-Watson wanted his threats to be believed so that he could continue to exert control over Madison. Threatening to throw the baby got Madison to back off. Threatening to kill her got her to stay away. Greene-Watson wanted to make more of the fact that he was emotional when he made this threat, but he was emotional when he made the first threat too, and it was clear that Madison believed both of them. Further, Greene-Watson's argument that he's a hothead doesn't absolve him of the criminality of threatening his wife's life. The AFCCA also tackled the evidentiary issue of the uncharged misconduct that the military judge admitted under 404B, the evidence of the relationship-ending incident from February 6, 2022. The AFCCA was tasked with determining whether the military judge abused his discretion when he permitted the evidence to come in. The rule about propensity evidence, 404B, provides that generally the evidence of a crime, wrong, or other act by a person is not admissible as evidence of the person's character in order to show the person actually acted in conformity with that character on a specific particular occasion. Evidence of a crime, wrong, or other act can come in to prove motive, plan, intent, or the absence of mistake. As applied here, the February 2022 evidence couldn't be used to prove Greene-Watson actually communicated a threat in September 2020. But if it was offered to show Greene-Watson's motive or state of mind, it might be admissible. There's a 3-part test to evaluate whether evidence is admissible under 404B. First, the court must consider whether the evidence reasonably supports a finding by the court that the accused committed other crimes, wrongs, or acts. Second, the court has to determine which fact of consequence was made more or less probable by the existence of the evidence. The third and final consideration is a balancing test, to determine whether the probative value of the evidence substantially outweighed the danger of unfair prejudice. On appeal to the AFCCA, Greene-Watson contended that 404B evidence could not include acts that followed the charged act, that it could only include acts that predated the charged misconduct. The AFCCA disagreed with that interpretation of the law, citing the favored approach from CAF and 7 of the federal circuit courts, which permit post-misconduct evidence to come in under MRE 404B and the analogous Federal Rule of Evidence 404B. The military judge had found that the February 2022 uncharged conduct was substantially similar to the September 2020 charged conduct, and therefore qualified as a common plan or scheme. Greene-Watson argued that the two couldn't just be substantially similar in order for the evidence to come in, but rather were required to be almost identical. The AFCCA decided they did not want to accept Greene-Watson's invitation to turn precedent on its head and concluded the two events were similar in terms of the catalyst for the two arguments: Greene-Watson's willful, aggressive behavior, including death threats in front of James, attempting to keep Madison from leaving, and preemptive phone calls to 911 to try and undercut Madison's report or possible report. The common plan or scheme to intimidate Madison between the two events went to whether Greene-Watson's threat was wrongful. In all, the AFCCA concluded the military judge did not abuse his discretion when he permitted the evidence of the February 2022 altercation to come in. The evidence showed Greene-Watson's propensity for controlling and manipulative behavior, which couldn't go to whether he actually threatened Madison in September 2020. But it could be used to show it was more likely that Greene-Watson used a common plan or scheme to use threats against Madison to dissuade her from reporting his misconduct. It could go to whether Greene-Watson's threat was in jest or offered for some other innocent or totally legitimate purpose. Then the AFCCA pretty handily dismissed Greene-Watson's argument about Madison's unsworn statement and ultimately affirmed the judgment. Greene-Watson further appealed the issue of the 404B evidence to CAF, which generally affirmed the AFCCA, but it took 4 opinions to accomplish that. Throughout their 4 opinions, they did a pretty in-depth analysis, but they also got to use one of my favorite shortcuts. First, they concluded the military judge did not commit error. Then they concluded that even if the military judge had bungled the admission of the evidence of the February 2022 incident, that supposed error did not materially prejudice Greene-Watson's rights. Errors without impact are not reversible errors. Thank you for listening. If you enjoyed today's episode, please share it. I invite you to submit case suggestions and feedback to conductunbecomingpod@gmail.com or on conductunbecomingpod.com. Join me next time when we untangle a perplexing claim of self-defense. Until then, take care. Conduct Unbecoming is a podcast where I get to talk about interesting crimes and cases that involve U.S. military service members. I research, write, and produce the podcast myself. The opinions expressed are my own, and perhaps it's obvious. Conduct Unbecoming is not approved, authorized, or endorsed by the Department of Defense.